All right. Good afternoon. Good afternoon. Thank you. Better. Welcome back. Hope you had a nice weekend. Any questions? Anything in your mind? Okay. I'll begin by briefly summarizing our last two classes and hopefully segue into today's class. So far, our entire study of property is quite limited. We focus on basically finding and taking stuff, right? In our first class, we discussed two concepts: acquisition by discovery and acquisition by conquest. These are two doctrines that developed very long ago, which allowed people to acquire both land and, in some cases, the people who lived on that land. And that could be accomplished merely by seeing it, or if necessary, using physical force. That is, discovering it or conquering it. In our second class, we moved on to something a little bit more familiar. Please be on time. Thank you. In our second class, we moved on to something more familiar, which is acquisition by the rule of capture. Now, I want to be very clear about where the rule of capture applies. It applies to things in the wild. It applies to things like animals, a duck, a whale, a fox. We'll study next class applies to things like oil and gas, right? Things in the wild. If I drop a pencil on the desk and I forget it's there, and then you pick it up, you've not captured it. You've actually just found lost property. And there's a different topic on that we'll study later this semester. So when you study the rule of capture in your notes, make sure you only use it for wild things, what are called fugitive resources, things on the move, right? If I, again, drop a pencil here and I forget about it, you didn't capture it. That's not the correct doctrine, right? What does that mean in the exam? If I have a wandering fox, you can use the rule of capture. If I have a mislaid wallet, you're not using the rule of capture. For the first two topics, the acquisition by discovery doctrine and the acquisition by conquest doctrine does not apply to foxes. It does not apply to animals. It applies to land and perhaps the people on the land, right? Those first two doctrines were how do you actually acquire land, physical territory, right? I promise you at least 5 of you in the exam will use the rule of capture to acquire a new country. That's wrong. Another 5 of you will say, you're laughing, you will. I'm telling you, you'll do it anyway. And another 5 of you will say, I discovered the fox, or I conquered the fox. No, that's not right. So keep your doctrines right. Conquest and discovery concern land, territory. Capture concerns fugitive resources, things on the move, animals, oil, stuff like that. Okay, gas. Things are fluid, as they say. Okay. Everyone get that. I'm warning you, you will screw up in the exam, because it happens every year, but at least I gave you fair notice not to do it. So I feel my conscience is clean. What you do from there is your problem. Okay? Okay. All right, let's start with today's case. Now, you probably saw the syllabus like, Josh, what the hell is this, right? Why? This isn't crim. I did crim. Why are you making me do this crim stuff? The article I gave you, The Case of the Speluncean Explorers, is a law school classic. It's been taught probably at every law school for the last half century in various points. I took an upper level class, but I liked it very much. And the reason I gave it to you is not to see what you think about criminal law. That's not why I gave it to you. Rather, the judges in that case, there are separate opinions. Each of the separate opinions illustrate ways that all judges rule, right? They're kind of like stereotypes. Like this is one type of judge, this is another type of judge. As you go through law school, you will see the different moves that these judges made in all of your classes. In fact, I'm going to use this class to illustrate Pearson V Post, how the judges in Pierson resemble some of the judges in the Speluncean Explorers. But I give this to you not because people eating each other, I know it's kind of gross, right? I give it to you because it illustrates how judges think. And ultimately what lawyers do is make arguments to try to appeal to judges, courts, whatever forum you're in front of. So this is a useful article, right? In fact, there's very little you remember from this class, I promise. You'll remember the foxes, right? You remember the whales, maybe remember the ducks or the baseball. You won't remember most things I say. You'll remember the sort of modes that these judges use. Although, I had a student who graduated last semester who's studying for the bar now. She said, "Thank you so much. I remember all the stuff you taught me in property one for the bar. Thank you." I was like, wow. I don't get that often, so at least for one person it stuck. But she said it was useful. So maybe you'll remember stuff, but you'll definitely remember this class, I promise. OK. Any questions? All right. Let's do the first case, Pearson V Post. And if you notice, I kind of jumped around your book. It's a little bit out of order. I wanted to do this case after we did the whale case and the duck case. I think it actually flows better this way. Pearson V Post is a classic. I think virtually every law student in the country reads it. I've actually done a survey of property case books. It's in almost every single property book. Like one or two, it's not. It's kind of weird, but virtually every case book has this one. Now, why is this case in every book? I think because the facts are so simple, right? It's such an easy to understand facts, and you have a majority with one opinion, and then you have a dissent with a completely opposite opinion. And then it gives students a very good sample of the different approaches to the rule of capture. Also, it's kind of fun, right? Think of like these two guys running around on a beach somewhere in Long Island trying to hunt a fox. It's, the facts are kind of engaging. OK? In fact, when I do the 1L orientation, did I do orientation? Yeah. I did this case, didn't I? So you've seen this already. Oh, you know my shtick. OK, good. I just did it a week ago for the 1Ls. Shtick is like a routine. I have to. I'm in Texas, remember. It's Yiddish, but you'll get some of that. OK. So let's start. Where did I finish off last time? Is that Carson? You're last? And who's next? Is it Corey next or? OK, so Carson then Troy. OK, so Carson, I'll call on you in a second, OK? So first, a brief note about the case. The case was 1805, right? Decided in New York in their highest court, which was then called the Supreme Court of Judicature. Just one note. In New York, it's something of an anomaly. In New York today, the trial court is called the Supreme Court. Did you know that? Do you know why? Oh, I'll tell you why. Remember the phrase from Cifro, general jurisdiction? The Supreme Court is a trial court of general jurisdiction. They have jurisdiction for all cases. That's why the trial court is called the Supreme Court. The highest court is the Court of Appeals. But at this point, it was called the New York Supreme Court. And we have two judges. Judge Tompkins wrote the majority, and we have Judge Livingston, who wrote the dissent. These were actually fairly prominent people. Judge Tompkins would become the governor of New York, and he served as vice president under James Madison. The other one, Justice Livingston, was appointed to the Supreme Court of the United States by President Jefferson. These were not schlubs. These were prominent people who rose to very high ranks of government. So their opinion, I think, is worth studying carefully. All right, Carson, without further ado, let's start off with the most basics, right? Pearson and Post, who is who? Which one's Pearson, which one's Post?
Post was the plaintiff, Pierson was the...
Is that right? Which is which?
Well, in this instance...
Who is the hunter? Which one was the hunter?
Post.
OK. Post was the hunter. And obviously, who's the other guy?
The guy who killed him.
What's his name?
Pierson.
OK, very good. So, Carson, who sued whom in this case?
Post sued Pierson.
Post sued Pearson. Right. So who's the plaintiff?
Post.
That's not what you said a minute ago. I think you flipped it.
Okay.
OK, very good. Thank you. In this case, Post is the hunter. He was the plaintiff, right? He sued Pierson. I'm going to describe Pierson as the jerk, right? That just makes it easier in my mind, right? Pierson is the jerk, right? Is that Troy?
Yes.
Troy, why was Pierson a jerk? Why do I call him that?
So Pierson, I think he's a jerk because...
I agree.
Post was doing things to kind of sort of get this animal and so that he could go kill it, and then Pierson and Hunter was spooked an opportunity to kill it.
Yeah, very good. By the way, I have this little stuff thing. It's kind of cute. Yeah. So I'll just leave this here. I forget to bring it to class most years. I actually remember it, so I was very proud of myself. But yeah, thank you so much, Troy. So the facts of this case are, classic. Has anyone done a fox hunt? I think I asked this last week. But we have hunters here, okay. All right, so Post was tracking a fox with his dogs, with his hounds, right? And this was a very elaborate procedure, right? It was almost, do you know the word aristocratic, right? It was something that like royalty did, that like elite people in English society, right? They weren't going out to hunt these foxes for food, right? This was sport. And they had, these bright red coats, and they had the dogs, and these hounds, and these horns, right? And they made this entire show out of it. So Post was tracking a fox, and he spent some period of time that we don't exactly know how much time. Okay? Pierson came along, and then Pierson came along and killed the fox, and he physically captured it. Okay. Now, why? I can't see your name. Is that S-A-M? Okay, Sanya. Sanya, why do you? I'm sorry. Oh, sorry. Samya. I'm sorry. I couldn't see the M. Sorry. Samya, why do you think this case ever went to court? Right? I mean, this seems like a pretty stupid thing to litigate all the way to the state Supreme Court. Why would this case actually even get to court? You're exactly right. The law was uncertain. My question is a little bit more basic, right? Why did Post, the hunter, sue the jerk? Why did they waste their time over something that wasn't very valuable? We're talking, dollars, few dollars of damages here. Why? Well, you're right. It was a case of expression, but why do you think the hunter actually brought this lawsuit? You're telling me all correct things, but my question is not the what, it's the why. Why do you think this case ever made it to court? Is that Alyssa? Why do you think the Post brought this lawsuit in the first place? Actually, that's pretty good. Did you read about this case? Good, yeah. They had a beef, right? Or maybe a fox, I don't know. But they had a feud between them. Right, these guys didn't like each other. Usually, when you see litigation get all the way to the state Supreme Court, it's personal, right? This sort of thing could have been resolved out of court for a fraction of what the lawyers charged. You'll learn this soon enough, right? What was the award of damages? Like $100, right? $120, whatever it was, right? The book said. The lawyers, I'm sure, charged quadruple that, right? This was not about a lot of money. And this is a lesson not just for this case, but for law in general. Often parties who are involved in litigation will fight for what you might call the principle of the matter. That's where you guys get paid, right? Often litigation is not rational. You just want to settle it, just give them $20 for the fox and go home, right? Because the fox, what are you going to do with it? You can stuff it, I don't know, right? But it's just a fox. So there was a lot of personal beef going through it, right? We know from some research that's been done that Post was this newly wealthy guy who recently came into money. He wanted to show everyone how powerful he was, right? And Pierson was basically a farmer. He was like, screw this. I just want to kill foxes because they eat my chickens and stuff, right? So you had these dueling societies clashing, right? Now, I think I'm there, right? Presley, did I call on you yet? No. Okay, Presley, don't worry, you're on deck. Presley, I go like this and like that. Okay, so Presley, let me ask you a question. What year was this case taking place? Okay, very good. Now, I don't expect you to know a lot about American history, but generally speaking, what's significant? I have the same adapter. Oh, very good. Or same brand, at least. What's significant about 1805 in America, just in general? What's going on in that time frame?
I mean, everything's starting.
Yeah.
Everything's pretty new.
Yeah, why is everything new? Just one more sentence.
Because they split off from England.
Yeah. I mean, I'm not your comic professor, but I'm sure you know this. In 1776, right, we had a Declaration of Independence. The United States fought a war of independence. And in 1787, a new constitution was written, ratified in 1789. And one of the things that actually happened in this period was the Americans started to abandon the English common law. They didn't abandon English common law all at once. It sort of happened gradually over the course of several years. But a lot of the English statutes, a lot of the English cases just fell out of favor. They didn't use them anymore. Now, that poses a problem, right, Haley? Why is it problematic if the American courts start just abandoning all this English common law that had been around for hundreds of years?
They wouldn't have any precedent.
Yes. Who said case first impression? He goes, Simon, yeah, you said a minute ago. I think she's exactly right. At this time period in New York, virtually every case was going to be a case of first impression because there was no precedent, right? They didn't have precedent to rely on. Now, Allison, what case could they have relied on, assuming precedent was still covered with England that we studied? What case might have been relevant? Yeah, tell me about the duck case. You're exactly right. Keeble versus Hickeringgill. What about, by the way, on your exam, please do not write the duck case. You're laughing, but you will. I ask you to know case names. In fact, in whatever outline you make, your case name should be listed prominently. You don't say just Keeble, it's fine, or Pierson. I don't need both names, but don't say the Fox case on your exam. Don't say the whale case. I just want to know the name of the case. Thank you. All right, she's writing that feverishly, right? So, Allison, let me ask this question again. What was Keeble versus Hickeringgill about?
It was about the destruction of, he was making the noise intentionally to disrupt the guy's land and the property on it.
That's right. And what was one of the other elements of that case? Why was it important that he built this duck decoy, this sort of trap?
He put in the hard work for it and the labor for it.
And where was the duck decoy located?
On his property.
And why was that important?
Because then he had the rights to it.
What do we call that doctrine? Do you remember? Anyone? Yeah.
Rationale solely.
Very good. Rationale solely. Very good. Thank you, Christopher. Rationale solely means you own the stuff on your land. Okay. So, Kelsey, let me ask you a follow-up. Was this fox on land owned by the hunter?
No, they said it's on, I think they ended up saying it's a beach, but they call it wasteland.
Yeah, it's a wasteland, basically Long Island, which I'm from Staten Island, which is more or less Long Island. Yes, there's a lot of wasteland there. So basically just like a deserted beach, right? Okay, so was the land on any sort of privately owned land, Kelsey? Okay. Would this case have involved Pierson interfering with Post's occupation? Like
If it was on,
yeah, it's on public land. In other words, was a duck case even relevant to this dispute?
I don't think so, because the whole point of that
Yeah.
was the owning the land.
Yeah, I think so. And they reference the duck case. They don't mention it by name, but they sort of talk about it, and they say it's not really relevant. So even if English case law was sort of available, I don't think it's on point, right? So is that Yancy? Can I say your name? Yancy, let me ask you a question, please. We don't have any British case law. We don't have any British statutes. We don't have any American case law. We don't have any American statutes. What on earth is a judge to do in this case, right? We have this dispute, Pearson Post. They hate each other, right? You're a judge. You're the judge in that court. What on earth are you supposed to do?
Well, they went with the ancient writers.
Why on earth are they turning to these ancient, long dead writers who didn't even know about America? America didn't even exist when these people wrote their doctrines.
Possibly because they kind of touched on stuff like that.
But why are they, you talk about legal writing, like you have binding authority, right? You have persuasive authority from another jurisdiction. What the hell are these ancient writers? What is that? I mean, I like them. They're really nice. I think they're fun to read. But why on earth is that even persuasive to a court? Bryce, why are these ancient writers who died centuries ago even considered persuasive authority for courts to not just cite as like a see also, right? That's like the basis of their opinion. They're saying this is our rule of law.
I think it establishes kind of a custom for.
Custom. So you're seeing, like we talked about the whale case, right? Again, be rich. Well, was there a single custom that was developed by these ancient writers? Did all the ancient writers agree? No, they did not. Right? And this is an issue that is not limited to this case, right? You're going to be, a lawyer one day, God willing, right? You're going to pass the bar. You're going to do great. And at some point in your career, you're going to be asked to resolve a case. Say, here are the facts, right? You can do your legal research, and you're going to find that there are two strands of authority, right? There's one set of authority that goes this way, and there's one set of authority that goes this way. And I'll tell you, they might both be binding, right? You can have a case where the same jurisdiction has two rulings that overlap and that go in different directions, right? It will happen, I promise. It's not because judges are stupid or bad. It just happens. Judges don't always read other opinions. You know, some judges maybe don't consider all the issues. It happens, right? So is that Christopher? So Christopher, you're a law clerk for a judge, right? And you write him a memo, and you say, look, Judge, there are two different sets of authorities. They're both binding in this court, and they cut in opposite directions. How do you pick which line of authorities you go with? I think, you know, they're two precedents. They're both binding us. How do you pick which one you go with?
I think that from a common sense standpoint, perhaps weigh the pros and cons of the outcomes of each policy.
Weigh the pros and cons. Okay, well, just tell me what that means. I think you're on a good track. Just spell that out a little bit, please.
So in the context of this case, talking about the kill and catch rule,
Kill and catch.
one must kill and take possession of
Uh-huh.
an animal to have ownership.
Right.
If you think through how that would affect hunters who engage in this type of business,
Mhm.
it would necessarily favor Pierson
Uh-huh.
because that's what he did. But then there could be a unintended consequence, perhaps, if there's a race to kill an animal and take possession of it.
Yeah.
That maybe people could get hurt in a way that wouldn't be present under, say, the mortal wounding with fresh pursuit.
So Chris, is it Chris or Christopher?
Either's fine.
So Chris, let me ask you another question. Are you equipped to weigh policy? Is that what the judges are hired to do, to make policy choices?
Typically not,
Ah.
but they frequently do.
Yeah, I mean, Douglas, judges are put there to decide legal questions. How can a judge possibly decide to favor hunters or farmers, right? Isn't that like a legislative branch decision than a judicial decision? How are judges even to make that sort of call?
I think it goes to, and I hate to jump ahead to this, but
That's fine. It's there for a reason.
what was it? Andy
Yeah.
says look towards
Yeah.
public opinion.
Yeah, it doesn't. He did it for me, right? You had the one judge in the Speluncean case said, let's look at the polls, right? Let's check for public opinion. What do people think? Maybe people are nodding. Yeah, that's what judges should do. Douglas, you think? Okay, I'll come back to you. You're shaking your head no.
Yeah.
Okay, I'll come back to you in a second, Dylan. Why are you shaking your head no?
Well, I know that laws are based on customs and what people typically do, but sometimes people, if you look at the time, 1800s, people can get things wrong, and people's
Yeah.
customs can be absolutely wrong. So
Sure.
in that sense, you shouldn't rely on public opinion.
Oh, so you think a judge weighing the pros and cons of policy is a bad idea?
I'm not saying it's a bad idea. I think in certain instances it may be a bad idea.
Okay.
In terms of the rule of capture in this case, I wouldn't disagree with it. The outcome that came
So you think
out.
it's okay over here?
Yeah, I think it's okay.
All right, so Dylan, let me ask you a question. I'll go back to the same question I gave to Chris a minute ago, right? You're a judge, you're deciding a case, and you have two competing lines of precedent, both of which are binding upon you. Let's say you consider policy, right? Let's say that you think policy is risky, people make mistakes, right? How do you decide the case if you don't know which precedent to pick? They're both of equal binding nature on you.
I would do what they did here and just decide which one yields more certainty.
Now, is certainty a policy preference? Is that different than what Chris and Douglas mentioned a minute ago?
I guess it is, yeah.
Sheila, what do you think? How do you decide it? You're a judge. You're sitting there. You have two binding lines of precedent. What do you make your call on to resolve that dispute? How do you resolve the conflict? You can't ask the legislature for what they think. There's no legislation.
So I guess in that instance, you're gonna have to make a choice. Like you're
Yeah.
gonna, like Chris said, you weigh the pros and cons, and then because the legislator has not already set something,
Yeah.
you're gonna just make the decision to the best of your ability.
Could you just
And
say,
legislator.
could you just say like the judge in Speluncean, not going to do it, I'm with peace, I'm out? He just like, sorry, not going to do it. Can judges do that? It's like, this is too hard. Yeah.
No. I don't think they can do that.
but
But
they-
he has to use like the law and
Guys, just one at a time, please. Thanks. Good.
the precedent that he has.
Yeah.
He kind of has to base the facts of the present case and then compare it to precedent, which one is the most applicable?
Yeah.
Because he doesn't have anything else. So.
Yeah, yeah. I think Jayla made a few important points. What I'm giving you questions I don't have an answer for, right? What I'm trying to make you illustrate, or what I'm trying to illustrate to you is law is hard. You're in this room for a reason, right? If I could just give you a Barbary manual and say, go take the bar and you're done with it, that'd be easy, right? But there's things that law school should convey to you that is not going to be clearly articulated in any sort of commercial outline. Judges are consistently confronted with very difficult questions where the precedent case in its entirety. And that could be because the precedents are, there's an absence of precedents. At some level, the law runs out, right? Written law, statutory law, precedent, whatever you want to call it, the law runs out. And judges of all stripes have to decide on some other basis. They can't just say, I withdraw, not going to do it like the other judge, right? I'm just not, sorry, too hard, right? I guess they can. They can resign. But you have a conflict here, a hunter and a jerk, right? And one of them's got to win. They can't both win unless you split the fox in half, which is, I guess, possible. And judges have to turn to things. Now, maybe they turn to weighing pros and cons. That's an inherently legislative task. Inherently, right? Legislatures have hearings where they have witnesses. You have a group of farmers come testify, and you have a group of hunters come testify to a hearing, and they say, here's what we think. And then the legislature makes a difficult decision about which group should be benefited and which group maybe can get burned, right? And that government makes the decisions, and they're accountable, right? If a bill is passed that helps the farmers and hurts the hunters can vote them out of office, right? That's how government, I think, works. But judges don't have that, right? They don't set general rules. They decide concrete cases. But by deciding concrete cases, their precedent affects disputes as a whole, right? Now, let's drill this down a minute. How is a judge to decide what benefits and burdens are warranted, right? I mean, I think Chris and Douglas made a few points. Are we wanting to encourage hunting? Are we wanting to make maybe safety if people are hunting too quickly? Those are hard questions, and judges have no basis in which to decide. They're not legal questions, but they do them anyway. And for reasons I can't begin to explain, our society has accepted this form of judicial review. And forget constitutional law for a minute, even in torts cases, right, or property cases, why do we accept judges making these decisions? We do. Beyond the scope of this class, we need to explain why, but we do. And you're going to have to explain it. Now, so far, I've been giving you the perspective of the judge, right? I've given you the perspective of the judge. Now let's flip it and be a lawyer for a minute. I think, Sarah, everyone called in already? This I didn't do? Okay, Tony, you'll get there eventually, I promise. I know people now in dread. This entire row's on dread. So Tony, right, you're a lawyer, right? And then you're arguing this case. And you're arguing for the hunter post, right? And you go to court, and you realize, as a smart attorney, that there's really no precedent that governs this. What's the argument you make to the court about why your rule should be preferred over the other rule? Like, what? I know that sounds like a stupid question, but why should a court adopt your rule when there's really no precedent one way or the other?
Probably rely on like rules and how he put in all his hard work into everything.
Yeah,
that he needed
well,
to
but
do.
that's you're just restating the rule. But the harder question is, why should the court pick your rule over the other guy's rule?
Well, I'm just going to play up why it was such a good idea for them to. Like, the judges put in their hard work to become judges.
Okay.
What if they were to do something and then someone else came along and just took that judgeship from them?
By the way, this is actually a very good argument. If you want to make an argument appealing to a judge, you have to appeal to the judge. So there was a funny episode of the Supreme Court last week. There was a case involving age discrimination. Basically in federal law, if you're over the age of 40, you can't be discriminated against. And so Chief Justice Roberts was very tuned in. He asked a question. He said, would saying, okay, boomer, be a form of age discrimination? And he is a boomer, right? There was another case involving a GPS. If someone put a GPS on your car, and they all drive cars. So I think actually Tony's making a good point. But my question is a little bit more basic, right? You're giving me an advocacy tip, which I think is a good one. My question, is that Heather?
Yes.
Heather, my question is a little bit more basic, right? How would you persuade a judge in the absence of precedent that one policy preference, fairness and rewarding labor, is better than another one? Like, why should a judge listen to you? What if a judge says, you know what, I want to do the other rule? Like, what exactly is it that lawyers are doing when there's no precedent that's clear?
I mean, you just do what you can to just make them think that you have a better argument.
Yeah,
than
but what's
whoever
better?
you're going against.
What I'm trying to get at is, when you say what's a better argument, right? You say maybe more persuasive. It's a synonym. The judges themselves have the same struggle, right? And that's why I'm trying to. It was not a fair question because there's no right answer. But what I want to illustrate is, you're only seeing cases from one side of the bench, but put yourself on the other side for a minute. The judges have no idea either, right? And they have to make tough choices. And often, no matter what arguments you put forward or how compelling you are, it may not even matter what you say. All right, any questions on that? I always like to give a little introduction to lawyering, whatever you want to call it, with this case, because it's so simple, but it illustrates how difficult even the simplest case is. All right, so let's start. Is that Clayton? Let's start with just the different arguments, right? So what is Post's best argument, right? What are Post's lawyers arguing in this case about why Post should prevail?
Post is the one with the dogs, and so he's put in the work and has been pursuing and was working towards obtaining the fox.
Okay, what authorities, Chance, what authorities does Post rely on, or what authorities are most supporting Post's position?
So I had a bunch of the different theorists and all that stuff.
Yep, their names. Names actually are important, so we'll just.
When I've been trying to format stuff in my outline, so I'm making these wrong.
Do your best.
Barbarac?
Barbarac.
That too.
Close enough. Yeah, I know what you meant. Okay, Barbarac was a French philosopher who was a disciple of, you guessed it, John Locke, right? Oh, wouldn't it be easier to just say Locke in the opinion? No, of course not. They talk about Barbarac. Barbarac wrote a book basically commenting on Locke, right? If you think of it that way, he was basically a disciple of Locke. All right, so Chance, what was the Barbarac / John Locke opinion on this matter?
Basically, it was if you had put in all this effort, you had all these dogs, and you had gone through all this process to acquire this fox, that you had established that this fox was already yours and that you had ownership or a right to it.
Okay, very good. Is that Farron?
Yes, sir.
Okay, so one of the difficulties of the John Locke opinion is where do you draw the line, right? With the rule of capture, it's straightforward. You get the damn fox, right? But with the John Locke opinion, how much labor do you have to invest before you can claim the fox is yours? Where do we draw that line?
It's not certain.
No, it's not.
They haven't really defined that.
No. The dissent hints at one possible test. You know what that test is? It's mentioned towards the end of his opinion.
I know he talks about customs.
Okay. Mackenzie, you know which one it is?
I believe it's whenever you're within reach or have a reasonable prospect.
Yeah, just say that one more time, please, so everyone can hear it.
Within reach or have a reasonable prospect of taking physical possession.
Okay, so this is, I think, consistent with Locke. And the argument is, if you just look at the fox, it's not yours, right? If you just run after it, right, it's not over. But if was it within reach, or what's the second one?
Has a reasonable prospect.
Okay, very good. So the idea is, if you've come so close to it, right, that you're within reach, or perhaps you have a reasonable prospect of acquiring the animal, then it's yours. And I think what this rule is trying to reflect is you have to do most of the work, right? You have to get to a point where it's basically yours, except something happens to intervene. And I think this rule, makes enough sense. But of course, is it Timothy? I'm sorry, Allison. Sorry, no, I got really excited for a second. I'm sorry, Allison. What does it mean to have a reasonable prospect, right? Within reach, it's like, okay, my arm's there, it's there, okay, I guess I can reach it soon, right? But what does it mean to have a reasonable prospect? What's that phrase mean? Oh, that's good.
Almost there.
I don't mind if you kind of incorporate something learned elsewhere. Law is law, right? It's not like all criminal law was created in one world and property. These steps interact. So you're saying a substantial step, right? You've done. Oh, that's even better. Yeah, the last act, or yeah, maybe the superseding cause, right? Something stopped you at the last minute. Yeah, these are all. Look, again, law did not develop in a vacuum, right? In fact, a lot of torts came from property and vice versa. There's a lot of overlap. But yeah, exactly right. The problem, though, with this sort of reasonable certainty or reasonable prospect is what, Timothy? Why is this reasonable prospect element problematic?
Where's the line?
Yeah. And who's supposed to draw this line? Judges sitting in their chambers who were not there, right? Is there any evidence of how close you were to the fox?
All based on what people have.
It's all hearsay, right? It's all people think. There's no recording, right? There's no, people don't, they didn't Instagram live their hunts, right? We have no idea. I'm serious, right? I mean, today there's so much stuff that's recorded. You can actually maybe say like how far you are from the fox, but it's all hearsay. And I think the hunter might have a more inflated sense of how close he was than otherwise. All right. So the position of John Locke and Barbarac was adopted by the dissent, Judge Livingston. Now, the dissent by Judge Livingston, I think you could tell by reading it that he was being sarcastic, right? He didn't take this case very seriously. Now, he gave you a test, this reasonable prospect test, which I think is good for your notes. But Sarah, I get everyone, right? Okay, good. Back down. Sarah, why do you think Judge Livingston was being so kind of sarcastic and dismissive of this case? He just did not seem like he really cared very much.
Maybe because he felt like it's common sense.
Did he think this matter belonged in the Supreme Court of the state?
No, but I mean, yes, I do, because it's the principle that matters. You want to show people where, basically, like he said, where you draw the line of who owns something.
How would, if Judge Livingston had his way, how do you think they would resolve this dispute?
He would go off the labor theory.
Well, that's what he did, but it just assuming he could maybe direct the parties to do otherwise, what would he do?
I feel like he probably just doesn't feel like it belongs in the court.
Yes, where does it belong?
Between the parties.
And, Jasmine, where does this dispute belong? How should this dispute be resolved?
Just them outside of the courts.
Yeah. Let the hunters figure it out, right? Let the sportsmen figure it out. But here they're not in the same profession, right? They're not both hunters. One's a hunter, the other's a jerk. So they don't have like a forum, so they go to the court. So I think you have to read the dissent as saying, this is stupid, right? We're fighting all the way over a fox that's long dead. Why are we wasting our time here? All right, you want me to pick a rule? I'll give you a rule. Here's the rule, labor theory, right? Reasonable prospect. But we don't need to do this. Let them do it by themselves. There's also all this Latin in the opinion, which is kind of sort of almost be sarcastic. Did anyone look up the Latin phrases? Okay. One of my favorite one you do have to know, though. This word actually majority moves to the rule of capture. Okay? The majority moves to the rule of capture. But it doesn't really tell you too much about the rule of capture, right? Because there are different ways to actually capture an animal. By the way, corporos, right? Corp means body. You'll see this word in the law, like corpus Christi, like body of Christ. Corp means body. If you know what that meant, now you do. But there are different ways of capturing an animal. So Monique, let me ask you a question, please. How would one go about applying the rule of capture to something like a whale?
The person who gets the body of the whale.
Was there only one way for that to happen?
No. The one who, well, in the other case, it was the one who the whale washed up and they actually captured the whale.
Okay. So we know, right? We know that the rule of capture is not always straightforward, right? In the whale case, yeah, Chance. No, the majority opinion. The dissent was a labor theory. Okay, so going back to Monique's question a minute ago, right? The rule of capture can manifest itself in different ways. Remember in Gen v. Rich, the whale case. Some jurisdictions required you to actually attach a rope to the whale. Other ones said it's enough to have the rope attached with rope breaks, it's fine. Right? Other jurisdictions required you to make a mark with your harpoon, right? So even the rule of capture for whales can be done 3 or 4 different ways depending what jurisdiction you're in. Okay? The majority recognizes that the rule of capture can be used in many different ways. So is that Chelsea? Chelsea, what are the different ways that one might capture a fox? What are the different ways that one could do it?
Mortally wounding it so that it doesn't have freedom to keep.
Okay, and how would one mortally wound a fox? I know this sounds stupid, but just spell it out. You shoot it. Okay. Now, let's say you shoot in the leg and it sort of hobbles around, and a couple hours later it bleeds out and dies. Did you mortally wound it? In other words, while it's hobbling around on 3 legs, could someone else come along and take it? What do you think, Kinza?
Well, the book uses an example that you can use nets.
Nets. Okay. Well, we'll go to nets in a second. Let's talk about just shooting it first, right? To mortally wound an animal, does that mean you kill it immediately, or that you strike it such that maybe it bleeds out, hours later?
I would say the latter.
So what about while it's, sort of hobbling along and sort of bleeding and suffering? Is the animal up for grabs then? Can someone else take it? So until it actually dies, it's not mortally wounded? Is that Chris? Did you need a name tag? Or?
It's somewhere.
Okay. Chris, how do you mortally wound an animal? What does that mean?
Say in the case of the fox, it'd be mortally wounded when its leg was shot because it needs to kill other animals to survive.
But I mean, it's going to be alive for a few hours. It doesn't die immediately. It sort of hobbles along and eventually bleeds out. In other words, I shoot an animal, I hit its leg, and the animal can still kind of hobble along. Then you come along and you swipe it for me. Have I actually mortally wounded it yet? And when you get it, you stab it right away. You kill it. Now, this is a morbid class, I know.
So no, it's wounded for this situation would be you shot its leg, it's going to die in a couple hours, and then you're within a reasonable amount of time, you're in pursuit. Someone could see you in the vicinity of the animal.
So you're saying it's not even clear what it means to mortally wound. Is that what you're getting at?
I think it's clear. But
What's mortally wounding it? Is it when you shot it, when it dies right away, or maybe it bleeds out, or maybe it breaks its leg and it lives for a week on a broken leg?
I'd say when you shot it and it's certain that it will die.
So it's certain will die. In how much time?
Within a reasonable amount of time.
What's a reasonable amount of time?
It's for the jury to decide.
Well, it's a very good answer, but I think what you're telling me is there's not a single standard for a mortal wound.
Guess not.
No. Right. even the majority's rule, which seems pretty certain, is not very certain. Mike, let's talk about nets for a minute. Right, let's talk about nets. Why would a net constitute a rule of capture?
You have it in your possession.
Well, I just said you throw a net and the animal gets tangled, but before you actually get to it, someone runs away with the net.
You limit its mobility.
Yeah. What's that phrase? It deprives of there's a phrase that they use in the opinion.
Deprive them of their natural liberty.
Yeah, that's exactly what I'm looking for. The net deprives them of their natural liberty. Just, Mike, what do you think that means, a natural liberty?
Where they can't run or.
They can't go where they want. I think that's right. Right, so the court also says you can deprive an animal its natural liberty. That is capturing it, right? In neither case, either shooting it or getting a net, you have the thing in your hands, physically hands. By the way, there's a word that you probably had to look up, hopefully you did, called mancupation. Oh, I can't type in the letter N. Damn it. This is making class a little more tricky. Macupatio, right? Mancupation. This is a new one for me. Mancupation means physically capturing something with your hands, like mano, right, hands, getting it with your hands. But with the net and with the rifle, you're not actually capturing with your hands. Instead, you're using some sort of tool to capture it, either a bullet or some sort of a net. Okay? So the court says that the rule of capture doesn't actually require physically capturing the animal. Let me say it again. The rule of capture doesn't actually require capturing the animal. Huh? Right? That you can capture an animal without actually capturing it by depriving it of its natural liberty. So you might think the majority is really simple, really straightforward to apply, but even the majority opinion has some wiggle room. The majority opinion has some wiggle room. Okay? Everyone with me? All right. So the majority opinion and the dissenting opinion are basically fighting over an ancient question. The dissent relies on people like Barbrack and Locke. The majority cites some other long dead people, right? Who is the Joe, right? Joe. What philosophers is the majority citing? Pufendorf, and who else?
Justinian.
Yeah.
And
And one other guy with a G.
Oh, great.
Grotius. Hugo Grotius was Dutch, yeah. Just know their names are helpful to know. Don't have to know much about them. But Pufendorf, Grotius, they all favored a rule of capture with certain variants, that you could acquire an animal through making physical contact. But Pufendorf and Grotius rejected Locke, that you can merely acquire it by inputting labor into it. They said you can't get it by being within a reasonable prospect. You have to make some sort of physical touch. It didn't have to be with your hands. It could be with a net or a gun or a spear or I guess a rock, I don't know, whatever you want to do, right? But it has to be something physical that you actually target and propel at them. Okay? All right. So, Nancy, let me ask you a question, please. Why do you think the majority, by Judge Tompkins, went with Grotius and Pufendorf? It's like a Harry Potter thing, right? Went with Grotius and Pufendorf rather than the dissent that went with Barbrack. Why do you think the majority picked the authorities he picked? He could have picked the other ones. I mean, the dissents are well. The rule of capture.
I want to say that it's something that the court can more easily determine.
Oh, that's a good answer. Tell me why. Why can the court more easily determine or interpret the rule of capture?
Well, it gives them more leeway, right?
What do you mean more leeway?
It gives them, well, like you said, more wiggle room.
right?
Well, what do you mean wiggle room? I don't know if I use that word exactly, but what do you mean? I think I know what you're saying, but just tell me a little bit more clearly.
Well, when we're saying that capture could happen under all these different circumstances, and you have to be able to account for
Which is easier to apply, Nancy, the rule of capture or the labor theory?
capture,
Why is capture easier to apply?
because there's concrete evidence of it.
And what is that concrete evidence?
Actually touching
The
it
fox.
with your hand.
The fox, right? Imagine this. You go to court, right? Nick or Nicholas?
Either one.
Okay, so Nick, let me ask you this question, right? You imagine this trial, right? Pearson and Post. Who shows up to court with the fox?
Pearson.
Why does Pearson show up with the fox?
Because he's the one that
He's got the
Pearson
fox, right? So from an evidentiary matter, who has the stronger case?
Pearson.
Yeah, yeah. I mean, it sounds stupid, but when you're a court, you have to have evidence. You have to entertain exhibits, right? Exhibit A, I got the fox. Oh, let me actually hold it, right? I got the fox, right? Exhibit A, right? Habeas corpus, got the body right here, right? What does Post have in that trial? What does Post put forward?
He's just arguing that he did the labor and
How does he prove it?
doesn't have any good way.
The phrase, the possession is 9/10 of the law, does that count talking about?
That's not accurate. I hate that expression. I mean, someone recently told that to me. I almost went on a rant. I was like, a property professor? No. It's really complicated, right? So I wouldn't use that phrase. But it's a common expression that if you actually have the thing, it's basically yours. That is so not true. Yeah, I had a. If you ever go on an airline and travel international, they give you actually metal silverware. I inadvertently, and I apologize, I inadvertently put a spoon in my bag. It was for my daughter, and I wasn't paying attention, baby food, and I just put it in my bag. And then I wanted to bring it back on the return flight to give it back to the flight attendant. Like, why are you doing that? Possession is 9/10 of the law. I was like, no, it's not. It's not my spoon. So anyway, I gave it back, and they took it. They took it. By the way, do you know the business class blankets you're not supposed to keep? I didn't know this till actually recently. The business class headphones and stuff. And he's like, you're supposed to give them back, even on a business class flight. So anyway, it's true. I know, first world problems, right? Anyway, I travel a lot. We went to flight to Australia. It was really nice. Actually, it was 18-hour direct, beautiful flight, but it's very enjoyable. But yeah, possession is not 9/10 of the law. It's just, but the idea is having the thing makes your case a lot stronger than saying that you put all this effort into a hunt. Prove it, right? Did you have big dogs? You have beagles? You have hounds, right? How are you actually going to show this? Okay. Any questions so far? Yes, sir. Is that Douglas?
Yes, sir.
Go ahead.
So, would you say that it would be better for us to use depriving of the natural liberty rather than mortal wounding?
Oh boy, is it better? What do you mean better?
Easier to prove. Because what you were saying, what mortally wounds something, but
Yeah, I mean, I see your question, right? So his question is, what's easier to show, that you were in a reasonable prospect of striking it, or you mortally wounded it? Look, I think at least mortal wounding, there might be some blood. There might be some physical evidence, versus reasonable prospect. I mean, you're my hunter, right? What was his name again?
Blake.
Blake. If you think you're close to an animal, could it escape at the last second very easily?
Yes.
Is that common?
Yes.
So I mean, how would you define the reasonable prospect of catching a very speedy animal? Is that like something you could say with any certainty?
Not entirely. Even with foxes, you could be reasonably close to it, hunting it with hounds. They could be within yards of it, or you could have been tracking it for 3 hours and it disappears.
Yeah, I mean, I had a dachshund. She passed away, but I had a dachshund, and she was really fast. And I was like, I got her, and then she's at the other side of the room in 2 seconds. Animals are very good like that. That's what they do. They try not to die and be captured. So I think as difficult as defining what mortal wounding is, and this was my conversation with Mike over here a minute ago, and Chris, I think it's even harder to define what it means to be within a reasonable prospect of catching it. I think it's almost impossible, because every hunter is arrogant with like, oh man, I almost had him, right? And then it's like, the fox escaped. Like,
See, I think mortally wounded is a much easier concept to prove than being reasonably close to catching something.
tell me why you think that's the case?
Because mortally wounded, I think, is actually fairly easily defined. Mortally wounded means it is going to die.
So how would you define? Is it a kill shot? I mean, how would you define it?
It could be a kill shot. It could still be a mortally wounded shot.
Yeah, I can't see your name tag from here. Is that Ryan? Go ahead.
Mortally just means in a manner such that causes death.
Mm-hmm.
So, but for your actions, the animal wouldn't have died. I think that's pretty applicable, especially in a hunting culture. You shoot it in a place that causes the death of the animal.
Yeah.
It's much more applicable than whatever.
All right. Anyone else want to add? Again, I've never been hunting. I have no interest in doing so, but it's okie doke. All right. All right. Let's move on then. All right. So ultimately, I think the majority held that the rule of capture was, I think, easier to apply. The majority also suggested that the rule of capture will reduce litigation, right? Because it's easier to apply, less disputes will come to court, will clog the courthouses. I think that's a legitimate concern for, weigh pros and cons. That's legitimate. What are the policy arguments adopted by the dissent? Is that Jordan? Right. What are some of the policy arguments the dissent, Judge Livingston, considers?
The fact that he looks to the fact that Post had the large dogs and the hound, or like had these animals that made him.
What are policy arguments? I mean, I know this is a stupid question, but when I say, what are the policy arguments, what am I asking you about?
Like, what implication that decision has for society?
Okay. Let me phrase that a little bit differently, right? When you're talking about a case, I can ask you what? Facts, what is the holding? The why is the policy question. So why does a court reach this result, right? In other words, why does the dissent favor the rule of labor rather than the rule of capture? Right, you're right, implications for sure. But the why is, when I say policy, I'm asking why. Why is the court doing this? You might not have thought about it that way before, but that's what policy is. It's why. It's like, what are the rationales why we're doing this? Yeah, Jordan, go ahead. So what were the rationales why the dissent chose labor?
He talked about how like the I'm honestly not exactly sure.
Is that Ashley? Why? Why did dissent choose labor theory? Reward who?
The hunter.
Very good. Right. What did the dissent think would happen if the jerk won? I think that's exactly right. If the dissent prevailed, if the under the majority rule, the rule of capture, people won't invest the time and labor needed to hunt. Right? I think the dissent wants to reward the hunter. But to be clear, this hunting was not any sort of thing that was necessary for society. It was a sport. Right? This wasn't like, hunting whales. Whales you need for energy, for oil, right? This was just for funsies. And why are we rewarding sport? Indeed, maybe there's a better rule, right? Ryan, why do you think the farmer want to kill the fox? Just in general, why do farmers want to kill foxes?
Probably eating his stuff.
Eating their chickens, right? Under the dissent's, under the farmer's position, should you have to take all these hours to kill the fox with these big hounds and other stuff?
No.
What should you just do?
I mean, he did. The farmer wouldn't care how they died.
Are you tracking foxes on the beach?
No.
What are farmers going to do?
Just wait till they come.
Yeah, when the fox is near them, shoot it, right? I think. Tell me if I'm wrong, but they don't need to have these elaborate hunts. So if you take from a
they use kind of this rule to talk about the baseball and baseball thing?
Well, yeah, you tell me. I mean, how does this case relate to the baseball case? The Papa Hayashi.
It seems pretty similar in that the guy made physical contact with it, but he didn't.
Well, be careful. In Papa versus Hayashi, did they both make physical contact?
Yes.
In this case, Pierson, did the hunter make physical contact?
No.
No. And that's an important point, right? With physical contact, when both parties make physical contact, they can both rely on the rule of capture. In this case, the hunter, Post, cannot rely on the rule of capture. He has to go labor theory. You see the distinction?
Yes, sir.
Right? If they both touch the animal, imagine a struggle where the first guy shoots the fox and the second guy picks up the wounded animal. Then they both have to argue what it means to mortally wound. Right? Or imagine one guy throws a net, the other guy takes him out of the net and runs away with it. But here, the critical point is, Post, the hunter, never made contact. He was only within some distance of the fox. He never got to it. Make sense? Okay. All right. Anything else on the fox case? We've beaten it to death. No pun intended. Yeah, I'm sorry. Okay. Let's go on to the other one. Again, I know it's weird, but I think this will be worthwhile for you at the end. The case of the Speluncean explorers. Did you study in Crim Regina versus Dudley and Stevens? Remember that was the case where they were at sea and they had to eat each other. Well, this is roughly based on that. Not exactly, but similar idea. All right, so Jay, I think you're next. Jay, you want to just give me the facts, please, in the Speluncean explorers case?
Yeah, so there's the 4 defendants. They are...
Well, there was a 5th guy, too. Yeah, there were 4 defendants. There was a 5th guy. May rest in peace. Yeah, you forgot about it already. Swallow your words, right?
Yeah, they like caves, like almost in a movie kind of way.
They like caves, okay. By the way, do you know what spelunking is? Spelunking is cave climbing. Yeah, go ahead.
I knew what spelunking was.
Good.
So they're spelunking, and after they get in, there's a landslide, and then they get trapped in there.
Yeah.
And they have no resources because there's no wildlife or life in there.
Okay. Then what happens?
Well, I mean, human nature, we need to survive. They have a little communication device with the outside world. Lots of controversy ensues.
Oh, no, you got to do better than that. Controversy ensued. Like, yada, 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 right? You know.
Okay. So they knew that they didn't have much with them.
Right.
And then, like, 20 days passed.
Yeah.
And they were either going to, they had to face a choice, basically. They were going to meet death by starvation before they could be accessed
Right.
to them. And they had a time limit, essentially. I don't know how else to put it.
Okay, good. Thank you. Does everyone remember about 2 years ago, or actually it was in 2018, in Thailand, there was a group of a football team, a soccer team, who were going through a cave, and they had some sort of something happened. I remember exactly what, but they were unable to escape. Remember this? And they were trapped in there for, oh God, I'm just Googling it. They were trapped in there for more than 2 weeks, and they didn't have enough food. So you think this sort of case is not insane, but this stuff happens. Lesson, never go through climbing through caves. Just don't. Cassie shaking her head. No, I agree. But this stuff actually happens, all right? So the people inside are surprisingly rational, right? I don't know how I behave in the situation, but they actually are talking it through. And they realize that they're not going to get out in time. They don't have enough food. And they also learned that during the rescue, 10 people were killed trying to rescue them. I just want to pause on that for a second. Cassidy, what significance do you put in the fact that all these people died trying to rescue them? Does anyone think about their deaths?
I think they might have been concerned about their own liability.
Yeah.
Maybe not legal, but maybe legal, but
Yeah, I mean, we think about rescuing the people inside, but the people who die rescuing, whatever. In fact, with this Thailand cave, one of the rescuers died in the last few months because he contracted an infection by swimming through the waters. So, I mean, these rescues are not costless. You know, whenever there's a person who gets trapped in a mountain and there's an avalanche, people die rescuing them. And, you know, it's selfish. A couple years ago, I made people angry. I said, just let them go, right? It's not, is it really worth risking 10 people to save 5 people's lives? People weren't happy when I said that, but, 10 people died to try and rescue 5 people. I don't think it's an easy, Cassidy. To save a life, save the world, I know.
So that's 2 guys that died with the Thai cave thing, because another guy actually did die trying to rescue them when he was swimming through his oxygen tank.
That happens, right? I mean, just do you want it to save, is it worth taking 10 innocent lives to save 5 people who got trapped in a cave? That's not an easy question, which I don't want to answer here. But they eventually learned that they didn't have enough food, they didn't have enough water, and they learned that they would die before the rescue was even possible. They could live for maybe 10 days more. Okay, at that point, there was silence, and then one of the guys, Wetmore, calls on the radio, and he says, hey, what if we eat one of us, right? Will that help us survive? Again, the guy who ultimately was eaten had the idea. So that's, ironic, I suppose, right? And the doctor said, well, yeah, you can eat each other. And Wetmore then asked, can we cast lots? That was basically pull a number of a hat. I don't know what, they had a die or whatever, right? They just draw a number. And the doctor's like, whoa, that's about my pay grade. And they said, is there any judge or government official who can give us a sanction to let us do this? And they're like, no. And they said, okay, is there a minister or a priest? No. At that point, the messages stop and it goes quiet, and they assume that they were dead. Then a couple days later, they drew lots, and Wetmore won, or I guess maybe he lost, I don't know. And they killed him. He didn't object to the fairness of the proceedings. And then they were rescued. And after they got out, they were indicted for murder. So just let me pause here. There's no requirement that these people had to be indicted for murder, right? That's just, one of the most important decisions is not what the court does, but the choice of the prosecutor. Do you actually even bring the charges? This was probably an unpopular case in a lot of levels, so why they even bring the charge? But once they bring the charge, the judge has to do something about it. Trial. And then, of course, there's a lawyer on the jury. This is why, by the way, lawyers are not allowed on juries. Right? I got called for jury duty about a year ago, and you write your occupation as like a law professor, right? So in the middle of the jury, the lawyer's like, Professor Blackman. I was like, oh God, no. Tell us, what does this mean? I'm like, no. And then I got bounced very quickly because lawyers can control the jury. I can say, no, they're wrong. Here's what the law actually says. And that's why I didn't want to do it. But in this case, it was a lawyer on the jury who just said, we do a special verdict and we just find the facts, and then you find the guilt. And the judge said, okay. So the judge found guilt, and the sentencing was just hanging. There's no other sentence permissible. Then the jurors asked the president, basically the chief executive, to to commute the sentence so they wouldn't be hung. Then we got the opinions, right? And this is kind of weird, right? We get 1, 2, 3, 4. We have 5 judges, although one judge has 2 opinions, which makes it a little complicated. So basically 6 opinions. And these judges, I think, illustrate the different ways by which all judges resolve cases. And I think it was Douglas raised his hand earlier. There are some parallels that should be obvious to the Fox case. Not maybe right away, but that should be there. So let's take them in order. Ashley, tell me about Chief Justice Truepenny. What a good name, right? Truepenny. Tell me Chief Justice Truepenny, please.
Well, he lays out the facts and kind of basically has the point that he doesn't really like the law or the statute, but we have to abide by it because that's what it says. He does vote to lower the sentence, though.
So kind of like, we shouldn't interpret it using our feelings, but kind of I am with my point.
Facts don't have feelings?
Well.
Right. Thank you. Right. So I think True Penny is basically saying, let's follow the law regardless of the result. In other words, follow the law wherever it goes. I don't like the result, but that's not my job as a judge. Right? My job as a judge is to simply follow the law and not think about the results. It's a common approach. In fact, when most judges go through their hearings, this is what they always say: I follow the law wherever it goes. I'm often skeptical if that's the sort of argument that actually prevails in judges. All right, so that's Justice True Penny. Is this Amir next? Amir, give me the next statute by Justice Keene.
Keene, doesn't he say like murder is murder? Basically, follow the statute. Just don't. Like, they should be executed. Don't read the purpose of it. Just follow.
Yeah. Yeah. So, but what distinguishes then True Penny from Keene, right? What does True Penny add that Keene doesn't, Amir? True Penny makes a little request at the end that's sort of strange.
Didn't you say, was that for clemency?
Yeah. What does that mean, clemency? What? Yeah. So I think True Penny and Keene are somewhat similar, right? They both agree that under the terms of the statute, the guys are guilty, right? They committed murder. They took the life of another. There's no exception or anything. But True Penny is like, but hey, Mr. Chief Executive, Mr. President, it'd be really cool if you can just, commute this hanging. Sam, is it? I'm sorry, it looked like an S from where I was sitting. Cam, is there can judges do that? Send messages to the president and say, hey, can you just take care of this because I can't? Do you see any problems with that approach?
They would, they're trying to inject their personal preference into the formality of being a judge. Their job is
Yeah, I think that's right. Exactly, right? Is it really the role of the judge to send messages on official government stationery, right? An actual, in a court opinion, paid for by the taxpayers, pleading for the executive to take action? I mean, I'm troubled by it. You'll see this a lot. Very often, you'll see a Supreme Court decision, usually a dissent, saying, hey, Congress, we screwed this up. You go amend the statute. You go fix the statute, right? You make the change to the law. I am not comfortable about this, but some judges like it. Some judges actually enjoy this sort of exchange with the executive branch. All right, so we have True Penny who said, follow the law but seek clemency. We have Justice Keene, right? And Justice Keene says, follow the statute no matter what. Okay. But let's go to Justice Foster. Justice Foster actually has two opinions, and it's kind of weird. Or is it? I don't know. You tell me. Ricardo, what's the first part of Judge Foster's opinion?
His first opinion is that because of where they were beyond like the reaches of the
Oh, wow. What do you think of that argument, Ricardo?
I kind of agree with it because I do feel like the position they're in, he talks about them no longer being men of society, that they go back to being men of nature because of
What laws do you apply then? What laws do you apply then?
the law that they came up with.
Oh, that's very good. So I described John Locke's concept of the law of nature. Remember I talked about this? And in this sort of theory, we say at some point people were sort of wild. They were in the nature. They did whatever they wanted. But eventually they reached an agreement of how to establish a government for themselves, right? And this initial agreement was called the social compact, right? The people came together and said, here's what we're going to do. We're going to protect property and other things. Social compact. What Justice Foster is basically saying is, these people were beyond our world. They were in a different, basically different society altogether, right? Our laws do not apply to a neighboring jurisdiction. It's just it can't, right? Our laws stop at our borders. By the exact same logic, our laws stop. Some other law must begin. What law begins? The law that they created through their compact. Diana, what law did they create through their compact?
Well, they were saying that because everyone agreed on it, that was their own, government.
Yeah, the lottery system where they would draw the numbers and kill each other, that was their government, right? Right, that the government that they created was to resolve the disputed hand, which was to eat. Right, so they were not relying on Pufendorf and Grotius and Barbarac and the other guys, right? They made their own natural law, their own social compact. By the way, the notion of this society having no law is actually fairly similar to what New York was in the 1800s. There was no law governing the foxes. So you might think, oh my God, this is insane. But when judges go, right, they're effectively saying we have no law. Let's look to something else. Let's use something else to form our own compact. So the judge is looking. Okay. So the first Foster opinion was let's look to the law that they created. They created their own social compact. Who's that next to? Okay, that's Jenny. Jenny, what's the second half of Judge Foster's opinion?
He had a couple big points. I'd say his biggest one was that he brought up self-defense as being valid.
Oh. Well, Jenny, let me ask you this question. Does the murder statute have a self-defense exception? Is it written into the statute? In general, do murders have self-defense statutes written into them? Do they? You don't know. It's an affirmative defense, you're right, but is it written into the statute? Why do you think, Marcos, let me ask you a question. Why do you think self-defense was offered as an affirmative defense, even though it's not in the statute? What's the general thinking behind that?
Not every murder is illegal.
Yes, so give me more.
Well, he does say, quote here, self-defense is an example of breaking the letter of the law, but not the law itself.
Yes. This expression, the letter of the law, but not the spirit of the law. So is that Marissa? Why is self-defense not breaking the spirit of the statute, even if it's breaking the letter? You're taking the life of another. That's why is it breaking the spirit? Why is it necessary?
Can you rephrase it?
You said it was necessary.
Sure.
What was necessary?
Well, not self-defense, but doing something for the greater good.
Let me ask the question differently, Marissa. Generally, why do people, right? I really don't like Marcos. I maybe want to kill him. Why might I not kill him? What might be one to deter me from killing Marcos? I like you, by the way. You're a nice guy.
Your life would essentially be over as well.
How so?
There's consequences.
Yeah, death penalty, whatever, right? So deterrence is one of the reasons why we have a criminal law, right? I'm not going to go murder Marcos because that might result in my execution. Stuart, would the deterrence argument fly if Marcos and I were in a struggle to the death and only one of us could survive? Would I be deterred in taking his life because what might happen later?
You're in a struggle for your life?
Yeah, we're fighting to the death, like gladiator style.
No.
Exactly, why not?
Because you have justification.
Not because of justification.
Because you would be dead if you didn't win.
Yeah. You're dead anyway, right? So the possibility of a punishment later, it's like, whatever, I want to live to see another day, right? The expression, carried by 6 or judged by 12, right? Would you rather be buried by 6 people holding up a casket or judged by 12 members of a jury? And that's precisely why you have a self-defense exception. Now, that's not in the statute, but courts have read an exception into the statute because of this aspect of humanity. And Blake, has the legislature ever repealed that exception or actually gotten rid of it? Has the legislature said, no, you can't raise self-defense, you can't raise that defense? No. I'm sorry?
They have not said no.
And what's the effect of that? Society has said that then it's a valid defense, right? So we're saying, look, if courts can create exceptions for self-defense, Why can't courts create exceptions to the murder statute for eating your friends, your fellow hikers, in this sort of situation? Is that and? Okay. So that's Foster number 2. Then we get to Judge Tating. Is that Julissa? Judge Tating, I think, was one of the weirdest of them all. What's Judge Tating's position? It's kind of like, you've probably never seen this before.
Well, he really struggles with his internal emotional ability.
Yeah, he does.
And he can't put it aside to make an actual decision at the end of the day, so he just decides to not.
He just withdraws?
Yeah.
It's like, whatever. Yeah, it's like, meh, right? You know, an emoji, just, I don't know. But he hasn't cast a vote. And this becomes important, right? Because so far we have 2 votes to convict the guys. We have 1 vote. Is my math wrong? No. Yeah. So we have 2 votes to convict, right? And then we have this guy saying, I don't know. And then the other guy's like, it's fine. So we get to the 5th vote, right? Louisa, what's the 5th vote? Judge, what's his face? Handy. Okay, what is Judge? Why does Judge Handy think, or how does Judge Handy resolve this dispute?
That's about practical wisdom.
Does he think this case is hard, Judge Handy?
No.
So how would he resolve it?
That they should be convicted.
Okay, why?
Because the government says the laws say so.
What would he look to? What would Judge Handy look to? How would Judge Handy resolve this dispute?
He says they should be convicted.
Giancarlo?
He said they should look to public opinion.
Okay, why?
Because they know that they're guilty of murder, but they all struggle internally with that they should be convicted, so they decide to poll.
Yeah, they look at the poll, and what do the people think? What do the polls say?
90% of the people said they should not be guilty.
They should be pardoned, so we basically to not hang them, right? This is what a lot of people think is instinctual, right? You look to the popular opinion polls. I think someone mentioned earlier, I think it was Alan, often polls don't, sometimes people think things that you may not agree with. And sometimes polls lead you in perhaps a dangerous place if you go with what the majority thinks. You'll study in Conlon the idea of being counter-majoritarian, but there's risk to looking to polls. So he would say, you know what, we just look to what the people think. Okay, so then we have this bizarre split. We have 2 judges to affirm the conviction. We have 2 judges to reverse the conviction, and the 5th one, right? So what happens when you have a divided court? It affirms the lower court. So the conviction's set, and the guy gets hanged. 1 second chance. Now, why did I give you this case? I want to just walk you through this, right? One at a time. So you have Judge True-Penny, the Chief Justice, who says, we should follow the law, but we don't like the result, right? This is like saying, you know what, I think the jerk gets it, but really, Post should have had it, right? It's judges who rule according to the law, but then go ahead and express their opinion, which I think is what Judge Tompkins basically did. He's like, look, I think Post had the better claim to it, but the law says you give it to Pierson, right? And you have Judge Keene, who's basically the strict judge. As well, we give it to Pierson, too bad. It doesn't matter what's fair, right? It doesn't consider fairness. Then we have Foster. And the Foster opinion reminds me of Judge Livingston quite a bit. Because you look to what the arrangements are in sort of state of nature. How would people have resolved it on their own? As well, you consider purpose, right? What's the purpose of the murder statute? What's the purpose of laws concerning foxes? Are we trying to reward these showy hunts? Are we trying to encourage extermination of... And then we have Judge Handy, which I think is very much like Judge Livingston. We say, what would the people do? What would the hunters do? Let's take a poll. Let's take a survey. And then we have Judge Tating. I asked earlier in that side of the room, you know, what do you do if you're conflicting authorities? You gave me this answer, that answer. And Judge Tating said just, I don't know. I'm out. Peace. Right? I don't know. What you're going to find, I think, is in law school, is any decision you read from any court, you can find elements of these 5 judges in any opinion you read. This will come back to you, I think, at least. Chance, patiently waiting. Look, you're a judge with an appeal, and you have to decide the appeal before you. You can't call a convention of people. You have to decide a case by a certain date. You basically have a death sentence. Push that back.
Why not?
I'm telling you, the law doesn't let you do that.
Oh.
Right? At the Supreme Court of the United States or any court, there's an execution warrant saying we're going to execute on a certain date unless you say otherwise. That's the date. The court can't ask the parties to extend the deadline for an execution. That's the date set by law. So you have to move quickly. All right, other questions? All right, let me summarize a bit and let you guys out of here. When we talk about rule of capture, it sounds very easy and very straightforward until you realize that there are many kinds of rules of capture. You can have capture by grabbing with your hands, right? You can have capture by shooting it. You can have capture by throwing a net at it, right? Maybe you can have capture by mortally wounding it, but it gets away. But as difficult as that is to define, the labor theory is even more difficult because there's so many different ways to be within reasonable prospect of catching it. Okay.
So is one of the through lines the intent behind the capture?
One of the what lines?
One of the through lines of the types of capture, are they intentional? Do they have to be intentional?
I don't think you have a negligent capture. I'm not sure that would work. I think you have to. I think you have to deliberately try to get it. I mean, I can imagine if I'm just walking around and a fox jumps in my arms. I guess that's capture. I haven't really thought about it. I think you're screwed if that happens, right?
My Maltese got caught in a raccoon.
Your what?
My Maltese poodle.
Oh, your poodle. Okay.
Caught in a raccoon trap once.
Oh my God.
So that wasn't intentional.
That's terrible. Okay. All right. Anything else? I have no response to that. Thank you all. I'll see you on Thursday.